كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provides a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is LIVE, the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Good afternoon, everyone. It's my pleasure to welcome you to the 31st seminar in Phase 4 of our International Interdisciplinary PhDinprogress weekly seminar series. This is organised by the Global South Network. Before we begin, I'd like to thank Dr. Jeongwon Ryu, who's the lecturer in Leicester Law School and chief convener and founder of the Global South Network, for organising this weekly seminar series and all the work that he puts in. My name is Tom Frost, and I'll be today's chair. I am a senior lecturer in law at Kent Law School. I have a doctoral degree from the University of Southampton, and a lot of my research spinning from that is into the work and thought of the Italian philosopher Giorgio Agamben. I'm joined by two discussants and one peer commentator. The first discussant is Dr. Stuart Lakin, who's an associate professor at the School of Law at the University of Reading. Dr. Lakin researches in UK constitutional and administrative law, human rights law, constitutional theory, and legal theory. He is particularly interested in how debates in legal theory can inform UK constitutional law doctrine. He takes a distinctively Dworkinian approach to his work, arguing that different understandings of the UK constitution necessarily rely upon and must be defended in light of their underlying abstract moral theories. Other research interests include methodology in legal and constitutional theory, the public-private divide, parliamentary sovereignty, parliamentary privilege, prerogative powers, separation of powers and judicial review, as well as legal and political constitutionalism. The second discussant for today's session is Dr. Gian-Giacomo Fusco, who is also a lecturer at the University of Kent Law School. He studied philosophy at the University of Bologna and the University of Rome. He obtained his doctorate in law at Kent Law School in 2018, with a dissertation focusing on the concepts of sovereignty and legal normativity in the work of Giorgio Agamben. He's currently serving as Secretary of NOMOS, the International Centre for Law, Culture and Power at the Jagiellonian University in Krakow. And he's co-director of the Centre for Critical Thought at the University of Kent and part of the editorial board of exceptions, the European Journal of Critical Jurisprudence. Jeongwon Ryu is the peer commentator for today. Jeongwon is a DPhil candidate in the Faculty of Law at the University of Oxford. His thesis is on administrative law. It seeks to defend a distinction, which is now heretical, between jurisdictional and non-jurisdictional grounds of judicial review. He also works on general jurisprudence, mostly along natural law and anti-positivist lines. Other interests include special jurisprudence, political philosophy, especially in relation to democracy, and constitutional theory. Last, but by no means least, our today's speaker is Wang Lin, who is a second-year PhD student from Edinburgh University. He holds 2 bachelor's degrees, one in engineering and the other in law. He's interested in legal theory, the interaction between law and technology, and in his PhD research, he tries to defend a communitarian conception of the rule of law and explore its implications for the upcoming AI era. And today, Wang will present part of their PhD project titled Defending a Communitarian Conception of the Rule of Law. So Wang, you have 30 to 35 minutes for your presentation. After 33 minutes, I'll give you a 2-minute warning. This is followed by up to 5 minutes for each of our 3 discussants and peer commentators.
Hello, everyone. My name is Wang, and I'm glad to be here to share the paper I recently read. It's titled Defending a Communitarian Conception of the Rule of Law, Engaging Postima. So, first of all, I will share the initiative of this paper. The whole story begins from the institutional understanding of the rule of law. Actually, I heard in a heartful debate claims that the requirements of the rule of law only possess instrumental value. And it helps to, that is to say, it helps to facilitate whatever goal, whatever goals law have, even the evil ones. And Joseph Ross puts this claim further. His famous metaphor is that the rule of law to law is just like sharpness to a knife. Like an evil state can still achieve better credits in terms of the rule of law. Why is so? Well, this justification is that we need to keep the rule of law within rule of law instead of rule of the good law. So he says that if the rule of law equals the rule of a good law, we need to propose a whole social philosophy which is useless, which is meaningless. So the value of the rule of law can only be negative or instrumental. This claim is quite influential, but I can't help but doubt, is that so? So can the rule of law gain its independent normative force without sliding into the rule of the good law? If the answer is positive, how strong will this normative force be? With this question in mind, Gerard Postima recently published his book, Lost Rule. And within this book, I find 2 crucial rules that may help us to answer this question. The first crucial clue is a methodological. Postima claims that the rule of law possesses a moral foundation. The second clue is the substantial one. Postima claims that the moral foundation of the rule of law is in the membership, which is a complex value interweaving freedom, dignity, equality, community. So my goal in this paper, in this research, is that first, I will explain the 2 important ideas provided by Postima. I will locate it within the context of the broader rule of law scholarships. I will explain to whom all these claims target at. And then I try to develop these 2 ideas. Instead of being a totally Postima fan, I would like to be more critical, and I seek to develop his ideas. So my representation will be divided into 2 parts. The first part is defending the first clue, and the second part is substantial one. So in terms of the first part, Postima, I will claim that Postima belongs to the teleological approach, which is against the anatomical approach of the rule of law. Here we start from the anatomical approach. The core claim of anatomical approach is that it tries to separate the rule of law into different elements. And there are two major directions. The first direction is that the rule of law is separated into a list of institutional arrangements, which is mostly the fullest ad desideratum of the rule of law. Namely, law needs to be general, clear, etc., etc. And they claim that, yeah, this list of institutional arrangements is rule of law. That's all. And whatever results, when these institutional arrangements are realized, whatever we can expect is none of the business of the conceptual analysis of the rule of law. And the second direction is like they jump out of the institutional arrangements. They take the rule of law as a reserve of different kinds of goods. Rule of law needs to, for example, protect human rights, basic human rights, and justice, equality, etc., etc. So I argue that the biggest problem of this anatomical approach is that it lacks a uniting core. And I call the thin approach of the rule of law is that if we only focus on the institutional arrangements, several problems cannot. First, we need to determine the boundary of the institutional list. Where does this list stops? We can know. In addition, the institutional arrangements within this list sometimes conflict with each other, and we don't know how to solve these kinds of conflict. For example, the generality requirements always conflict with clarity requirements, because if you want law to be clear, you hope it to be as specific as possible. And last is that without a uniting core, we are unable to distinguish the rule of law requirements from other requirements. Like here I give an example, like being transparent can be both the requirement of the rule of law and democracy. But without this uniting core, we cannot tell these requirements. Does it belong to rule of law or does it belong to democracy? And for the thick approach, also, we need a uniting core. The problem of thick approach is that it gives too many cores, too many cores, too many values. So the problem is the same. It cannot solve the conflict between different values, and it cannot avoid from the danger of sliding into the rule of the good law, like turning the rule of law into a hodgepodge of goods. We can learn some important lessons from the so-called failure of the anatomical approach. First, we need a uniting core, one core to unite the rule of law as a coherent idea. And then, second is that such uniting core must correspond to the institutional arrangements of the rule of law, and so that we will guarantee that it is a conception of the rule of law, not rule of good law. And the third point is that we must keep in mind that when rule of law is realized, there might be more than one normative result, but these results, not all of them have to do with the conceptual core of the rule of law. So it is against this background that I embrace a teleological approach. The core idea of the teleological approach is very simple. It requires the list of the rule of law institutional arrangements serve the goal of the rule of law. Like we need one goal, one core of the rule of law to unite those institutional arrangements together. And such goal, there are three requirements for this goal. Such goal must be singular, and it must be ultimate. That is to say, it must be ultimate enough to account for all the complexity of the rule of law. We have no need to resort to deeper values to explain the complexity of the rule of law. And the third point is that such call must reflect of the characteristics of the rule of law per se. So against this teleological, under this teleological approach, we will move to the second part. That is, here in this part, I want to defend a communitarian conception of the rule of law. And so first, I need to establish two perspectives again to the rule of law. The first perspective is the individual perspective, and the second is the communitarian perspective. So first, how can we find these two perspectives? I will argue that all these perspectives come from one common understanding of the rule of law. That is, the rule of law is to limit arbitrary exercise of political power. There is one question, that why don't we just take these limit arbitrary power arguments as the core idea, as the goal of the rule of law? My answer is negative, because it does not satisfy the second requirement of the teleological approach, that is ultimate. That is to say, limiting arbitrary power is far from being the ultimate value of the rule of law, because whenever we want to explain what arbitrary means, we need to resort to deeper values. One thing we admit one thing, that is, rule of law cannot rule out all arbitrary powers, right? So only a certain part of arbitrary power can be limited by the rule of law. So where is the boundary? Whenever we need to determine this boundary, we need to resort to deeper values. We need to ask why we want to limit arbitrary power. But nevertheless, this common understanding points out two perspectives of understanding the rule of law. The first is individual perspective. The second is communitarian. For scholars who hold the individual perspective, they will argue like this. Limiting arbitrary power is, rule of law is to limit arbitrary power. And why we want to limit arbitrary power? Because we want to protect the liberty or the dignity of individuals as rational beings. So this is individual perspective. It focuses the goal of the rule of law on the protection of individual liberty, dignity. But there is also another perspective, that is a communitarian perspective that has been long overlooked. The communitarian perspective can also be derived from the rule of law's goal, the goal of limiting arbitrary power. Because whenever the logic is like this, whenever we identify political power, actually we identify as a political community. The existence of the political power presupposes the existence of a political community. This is why Posima claims that the rule of law is not only a mode of governance, but also a mode of association. And within these two perspectives in hand, my goal here is to argue for some inadequacy of the individual perspective and try to justify the communitarian perspective. In my view, there are two major issues within the individual perspective, one methodologically and the other one is substantially. Methodologically is that it may violate the first requirements of the teleological approach, that is one uniting core. Philosophers defending the individual perspective struggle to achieve the balance between liberty and dignity. Like they find it is uneasy to choose one as the final ultimate goal of the rule of law. So most of the time they will claim both values at the same time, like Joseph Rawls claims the rule of law is to protect liberty and also dignity. And Hayek also has the same problem. In terms of the substantial issues, first, the individual perspective have the danger of slipping into the rule of the good law, because they identify the ultimate goal of the rule of law as protecting individual liberty or dignity. But they will always face a situation that is the content of law may deny the liberty or dignity, individual liberty, individual dignity directly. And if they deny this situation, their claim of the rule of law as a moral good it's just like a wolf in a sheep's cover. And if they admit this, their claim was slide into the rule of a good law. And the second aspect is the most important aspect I want to focus. That is, the individual perspectives overlooks certain distinctive aspects of the rule of law. They are all communitarian perspectives. For example, the law, the territory limitation of the law. That is to say that law always come into force within a certain territory, within a certain community. And instead of, in the content of law, other than rules guiding individual behaviors directly, there are also lots of contents that defines the basic elements of our community life. Like we have in the law, we can find the concept of property, the concept of contract, etc., etc. And law also defines how we conceive our community life, namely how we formulate the past. We have the law of evidence, and how we deal with each other presently. We have the law regulating civil capability. And the law also regulates how we can expect in the future. That is, our actions according to the law will be protected in the future. So, in a nutshell, the problem of individual perspective is that it presupposes the existence of a political community, and then focus on the protection of individuals within such community. But the reality is, the rule of law also plays a crucial role in shaping the political community. And to put it more bluntly, the rule of law defines a specific type of community. And this perspective has long been overlooked. So with this in hand, I think it's time for us to reconsider the rule of law from the communitarian perspective. In forming this communitarian conception of the rule of law, the major issue we need to tackle is that what kind of this rule of law community is. Here we have Postema's membership argument. Postema argues that such community cherishes the value of membership. This value is represented in the quality of the relationship between members within the community. That is, each member enjoys equal status by holding each other accountable under the law. This is quite a complex idea. So I try to divide it from two directions. The first direction is that we have equal status, but equal status of doing what? And the second direction is that in virtue of what do members enjoy equal status? So the first direction, equal status of doing what? Postema's answer is directly that members have equal status in holding each other accountable under the law. And my goal here is try to limit or to change this expression into applying the law. Here is my justification. Why Postema argues that we need to hold each other accountable under the law, why this is the requirement of the rule of law. Postema's argument is like this. Postema argues the core of the rule of law is to limit arbitrary power. And the rule of law does this by holding power wielder accountable under the law. And if this is so, the rule of law will inevitably suffer from the accountability chain. That is, at the end of this chain, there will always be someone cannot be held accountable under the law, because what this person says is law. So in order to solve this problem, Postima promotes accountability network. That is, each other needs, every members need to take each other accountable under law. So vertically speaking, the government needs the supervision from civil society, and horizontally speaking, the powers within the political power need to be separated, like the legislative branch and the judicial branch need to check and balance with each other. The problem of this argument is that Postima take the accountability network, or say holding each other accountable under law, as merely an instrumental arrangement to serve the goal of limiting arbitrary power. So the status of accountability network is downplayed. But if we come back to the rule of law, come back to the very first point, and we will see what the rule of law community looks like, we will find that the rule of law claims not only to limit arbitrary power, but also to govern how ordinary citizens interact with each other. As a matter of fact, this part, the interaction between ordinary citizens, occupies a lot within the rule of law community. Like they interact with each other, they're forming legal relations with each other, and not all, and most parts of these legal relationships don't go to the court, don't go to the authority department. So here I think that it's more plausible to take the requirements of ordinary citizens to apply the law at the very first of the rule of law's claim, instead of an instrumental arrangement to realize a part of the claim of the rule of law. The claim of the rule of law can be revised as the rule of law requires each member within the community apply the law whenever the law exists. The rule of law sets a public standard for all. Compared with holding each other accountable under the law, recall each member's applying the law, each member is equal in terms of applying the law is a more modest claim, as it distances the rule of law from the problem of legislation in the very first place. Okay, so the second direction is that, in virtue of what do members enjoy equal status? Postima does not specify on this point. His view that membership is a complex interwoven between liberty, dignity, equality, and community only adds confusion to this issue, instead of shedding light on it. So in my view, we need to introduce a distinction. That is, we need to distinguish characteristics that are universal to individuals. In this case, it's liberty, dignity. From the characteristics that are specific to the individuals. In our case, it's the communitarian background of individuals. These two characteristics can be the qualifications of equal membership. The qualification of rule of law may include these two characteristics, and the specific characteristics is like for the universal characteristics, it is used to distinguish human agents from non-human agents, and the specific characteristics is used to distinguish human agents in one community from the other. So for the universal characteristics, the moral appealing of the rule of law is that it cherishes humanity. And for the latter, the moral appealing of the rule of law is that whatever these specific qualifications are, once determined, they apply to all members within the community. So finally, we come to the concluding remarks. With this communitarian conception of the rule of law, we can see the independent normative force of the rule of law lies in its claim of shaping a community where members enjoying equal status in applying the law. And the qualifications of this membership include universal characteristics inherent in human beings and specific characteristics determined arbitrarily by a specific community. Therefore, when we discuss the normative force of the rule of law, we need to discuss it separately. That means we need to discuss it according to the specific conditions, context. Why so? Here I apply the Kantian deontological libertarianism. Kant's argument is that justice enjoys prior status, it is derived from the characteristics universally shared by human beings. So justice is always prior than goods. Justice is non-comparable than goods. So in our case, if the rule of law gains its normative force from the universal characteristics, then it cannot be sacrificed. Rule of law always needs to be obeyed. And if in a case that the normative force of the rule of law is derived from the specific characteristics, in this situation, this normative force is equal than good, and it can be sacrificed. It can be balanced. That's all my ideas, and I welcome all comments and remarks.
Right, good. Here we are. So yeah, thank you very much for that insightful presentation. Well within your time as well, so I didn't even have to make an announcement, so thank you. So what we have is two discussants and one peer commentator. I'm just checking now. Are you happy for those three speakers to go, and then we give a chance for Wang to reply after that? Yep, lovely. So Wang, what we'll do is we'll have Dr. Stuart Lakin respond first, then Dr. Gian-Giacomo Fusco, and then we'll pass over to the peer commentator Jeongwon, and after that you'll have an opportunity to respond to any or all of them. I'll also ask for attendees, if you have any questions, please put them in the chat so we can see them, and if we have time at the end we'll be able to hopefully respond to a few of those as well. If I pass over to Dr. Stuart Lakin, I will give you about 5 minutes or so, and I will announce when you have about a minute left.
Thank you very much. Can you all hear me okay?
Yes, we can.
First of all, if I can just congratulate the speaker on a very rich paper. And I don't know whether I'm going to be able to give a response that is worthy of all the ideas you've just given us. I mean, you've covered so much territory in a short period of time, so you're doing great things in your PhD. I think it's impressive. So unfortunately, I haven't read Posthumer's latest book, but I'm familiar with his writing in the past, and it resonates a lot with my interest in Dworkin, because there are certain close connections between the two. So one part of your talk that interested me in particular was the idea that Posthumer's idea that we hold each other accountable, which you didn't seem to like. You preferred, I think, applying the law to that. And I suppose this is partly comment, partly question, partly suggestion. I wonder whether you might look into this idea of holding each other accountable a bit more deeply, and try to get I mean, as I understand it, the sense of what Posthumer's saying, which again ties in with things Dworkin says about the responsibility each of us have to each other under the law. And it's this slightly counterintuitive idea that it is for each of us to argue from our own, what Posthumer calls Protestant convictions about what the law requires. And that engages deep moral beliefs and interpretation of what our commitments as a community are. So I didn't quite get a hang on why you didn't like this idea of holding each other accountable, but I think perhaps sharpening the target might be valuable in this respect. So that may have made no sense at all what I just said, but I think that was an area I think is an interesting one to develop. The other comment I wanted to make was about your dichotomy between individual and communitarian conceptions of the rule of law, and you say several times that this is an underexplored aspect of the rule of law, the community aspect. I'm not sure that it is. I mean, I think you could look to. I mean, Trevor Allen is a name that springs into my head, who really tries to marry together the individual and community dimensions of the rule of law. And I think most liberal theorists, Dworkin, Allen, for instance, would see it as a bit of a parody of their theories, that they ignore the community aspect. So that's one thing. The other is this term communitarian. I think you run the risk of opening the disturbing the hornet's nest with that term. I don't know whether you mean it in its the sense that political theorists often use it as a challenge to liberalism. If so, I think you needed to say a lot more about how there can be a communitarian set of moral and ethical standards which necessarily belong within the rule of law. I didn't take you to be saying that. In fact, I took you to be saying the opposite to that. So that might just be terminological, but it's something to be a little bit aware of, I think. So I don't know whether I've managed to give you any questions as such, but I suppose let me close with this as a question, and perhaps this can be seen in light of the other points I've made, and that is, what is your problem with the rule of law equating to the rule of good law? Why is that? Why is that something you have to resist? And I think with that, I shall end, and thank you once again for your intriguing paper.
Thank you very much, Dr. Lakin. I'll now turn to Dr. Fusco.
First of all, I joined Stuart in claiming that this project is impressive, and from my point of view, it looks also quite self-contained in a sense, and it has a quite clear inherent structure. First of all, I have a question, and it's about the scope and the purpose of the project. Is this project like normative? So you try to claim how the rule of law should be in, I don't know, in contemporary, the West, in a global setting, or whatever. Or you limit yourself at developing developing a critique of posthumous work, and this is the first general question, because I think it's not very clear from the material I read, and also from your presentation, and not that the two are excluding each other, or one is more important of the other, but these two. I mean, I would like to hear more from you about what is the general purpose of this project. Then there are, I think, more, I would say, juicy questions about the substance of some of your claims, and especially the very end, when you talk about, of course, when we think about the law shaping a society and a community, of course, this is quite a relevant and discussed idea, So the law is informing a community, and we know about that. But the way in which the law is informing a community is in a negative way. It's always in a negative way. So this is our law, this is our jurisdiction, and it's ours because it's different from somebody else's jurisdiction. So so when we say that we need to distinguish characteristics that are universal to the individuals, liberty, dignity, as example from ones that are specific to the individual, and in our case the communities. What do we mean? What do you mean by liberty, dignity? Because this concept have long history and are not uncontroversial in themselves, and especially I'm happy that you're brave enough to say that such qualifications, the qualification of the human, is arbitrarily determined in each specific community. And this is a quite I would say realist statement. So this is as it happens. This is the reality of a community. So this the artificiality of the delimitation and definition of the criteria that each community establish for themselves, to determine the membership to that community. And so if you can tell us more about what you mean with this. And then and another interesting claim. So you claim that the normative force of the communitarian conception of the rule of law lies in its claim of shaping a community where members enjoy equal status in applying the law, and this is also a point that Stuart made. And the normative force of the rule of law does not enjoy prior status when compared with other goods. And also, if you can explain what you mean by this. And then this is perhaps because of my background and my education. This project, I mean, from looked from outside, it seems as if you're trying to articulate and to find, as you said, a unity core or Unitarian core of between the two main conception of the rule of law. Which is the thin and the thick, or formalistic substantive, as you prefer. And you try to develop this communitarian idea as a sort of a third way, an alternative, or as a unity core. But it looked from the outside. I found similarities with the overall project that ended in the 90s by Jürgen Habermas in the book Between Facts and Norm. There you can find, in a sense, a justification of the need for a specific institution, the formal law, to determine, in a sense, the law as a form of an instrument to integrate a community. And there you can find also, a universalist claim of what does it mean to be a human in a community. And Habermas famously found this in language. Okay, so I conclude with a comment. Do you think it's, a comment, a suggestion? It might be a good idea to look at Habermas as well. And thank you.
Thank you very much. I now turn to Jeongwon Ryu. Jeongwon, you have 5 minutes.
Yeah, thanks. Yeah, just two quick things. First, I sometimes publish under Angelo, in case that I just didn't want two versions of me floating around. And the second is, I apologize. I kind of ambitiously have another meeting soon, so I may have to rush off. But yeah, okay. So Wang, yeah, this was a great paper. I really enjoyed the presentation and the slides. I'm just going to do, I think, two quick things. The first is, so I should start by saying I don't really agree with either Hart or Raz on the rule of law, but I'm sometimes in a position in these sort of conversations where I have to sort of be the token Oxford sort of defender, if you will. So let me just start with one thought. So you cite Hart and Raz and suggest that they are examples of what you describe as instrumental values of the rule of law. So the thought is that Herbert Hart and Joseph Raz and others believe that the rule of law is grounded in a value of which is only instrumental, right? And then the analogy to the sharpness of a knife is there as well. So I think that claim is often misunderstood. Neil McCormick, in his sort of like quasi-intellectual biography of Hart, attacks this interpretation. I think he's right about that. I think both Hart and Raz are clear that the rule of law has intrinsic value. Hart says that it's concerns with, the dignity of a choosing system, where individuals are able to sort of choose to avoid sanction, and that this is somehow linked up to their dignity. And Joseph Raz, when he talks about autonomy and the requirements of what respecting someone's autonomy entails, and that involves treating them as a rational agent. Now, what both Hart and Raz and John Gardner and many people who pass through Oxford believe is that even though the rule of law is of intrinsic value, it is also a negative value, which is also a phrase that I think you cite. So the thought here is not something can be of intrinsic and quote unquote negative value on these theorists' perspective, because what they mean by negative is not that it's not intrinsically valuable, but rather that law itself comes with costs, right? So law allows for the coordination of state power in such a way as to threaten autonomy or dignity or freedom in distinctive ways. And the rule of law is of intrinsic value to the extent that it is a sort of meant to be a solution to sort of ameliorate, right, or prevent these sort of grave problems. So it's of intrinsic value to the extent that it prevents an intrinsic wrong, right? But I don't think it's like sort of instrumental purely in the sort of, I think so. Raz has this analogy to the sharpness of a knife, and you can use a knife for good or bad. But I'm not quite sure I think he's using it for a certain point, and I think it's overread. Now, as for your own, and by the way, so I should say, like, so you suggested that there's a sort of challenge for rule of law theorists, which is to sort of construct a sort of unity, right? So you said that there should be a value that unifies these various desiderata of what you call an atomistic approach. I think they do have one. I mean, I don't myself think it works, but I think they have one, and it might be helpful for your project if you articulate it clearly and then criticize it. So I mean, I think myself and others call it, I think, a guidance conception or a guidance view. What Hart, Raz, I think how they read Fuller, although I don't think that's what Fuller meant. How they understand these desiderata is that, generality, clarity, retrospectivity, these are all requirements that help the law guide conduct, and by guidance, they mean a certain kind of direct engagement with individual rationality, such that these intrinsic values of dignity or freedom or all that obtained. Now, you might disagree with that, right? But I think they at least have an answer to what might unify these desiderata. And finally, on your positive proposal. So I myself am a Dworkinian, and I don't think that the methodological way that Raz develops the rule of law is the right one. But I do have one sympathy to, I think, a thought that John Gardner had and others. But I think this is one that divides Dworkinians and non-Dworkinians on the rule of law, which is what Gardner described as an asymmetry in the rule of law. So your engagement with Posthuma's work, right, suggests that what you find odd is, that you can sort of deflate, right, the notion of accountability to mere application. So the thought is, Posthuma is doing a lot with this notion of accountability, but you can just deflate it to simply being application, and most of the things he wants you can just get anyway. So my concern with that is, it seems to me like one thing that a rule of law theory must account for is that when I fail to apply the law in my daily dealings, in the sense of making a legal mistake or ignoring the law, this is no grave problem for the rule of law. But when an official fails to apply the law in certain ways, it is a grave problem. And it's a grave problem even if it's just a one-off official. So even if 99 officials in a community do well by law, if there's one official running around putting people in jail arbitrarily, that's a huge problem for the rule of law, even if it's corrected. And this is an asymmetry that Gardner and others, I think, discuss. It's one that I think follows from one controversial account of Dworkin's thought. Dworkin starts in Law's Empire with what he thought was something that everyone was going to agree on. It happens to be the case that very few people agree on it, but he thought it was common ground, which is what he called the force conception, right, or the force hypothesis. He thought that, Dworkin thought that, everyone can agree that law concerns the justification of, public coercive power. And I think if you start from that angle, right, that the rule of law has something to do with essentially force that comes in the name of a community, a certain kind of public value, then it makes sense why the rule of law would be asymmetrical with respect of that power as compared to, my daily interpersonal contract dealings. Thanks.
Thank you very much. And thank you to all our discussants and peer commentators. Wang, we now have some time for you to respond to some, any, or all of the comments made. You're very welcome to do so. And I will just have a look through. We have one question in the chat as well, which we can get to if we have time. If anyone else has questions, please post them in there. We will get to them. So Wang, over to you to respond.
Okay, thank you. There are no easy questions. So, quite a lot. And first of all, thanks for all these comments. They are very useful. And let me start from, the first question about my misunderstanding of Hart's rules. Actually, there are not instrumental lists of the rule of law. Yes, I agree with this. And I maybe the point here is not that what Hart or Ross actually means. Maybe I mislabeled Hart or Ross as an instrumentalist argument of the rule of law. Yes, maybe true. I will correct it. But what I just want to point out is that there exists this instrumental understanding whenever who claims for it. And yes, you are pointing out one important thing, that is Ross's claim that rule of law is a negative value does not mean that rule of law is does not have intrinsic value. Negative does not equal intrinsic. And I agree with this. And actually, this is the paper I'm working on. And I should put it previously at the first. That is, I think I don't agree with Ross's negative arguments because I think my basic understanding of the rule of law is that it requires all actions powers be exercised according to law, or else it is not an exercise of legal power. It is not a result of law. But in Ross's formulation, Ross argues that Ross says at first that my conception of the rule of law happens when the government is in its legal sense. That is, whatever this government do, even though it does not conform to the general law, it is still law. It is still an exercise of legal power. And I seek to claim that, yes, this is true, but this is a very small portion of the rule of law. It only applies to the legal discretion, that there is no general law and whatever I do is still law. So my action needed to receive guidance from general law. Yes, this is true, but the more general concern is that we have political power, bare political power, and whatever this power, if this power does not act in accordance with law, it is mere an exercise of political power. And I know it's hard to make this clear, but I just want to make this distinction, and I realize that's the negative and intrinsic distinction. Yes, and I will also argue that Ross's claim, when Ross and Hart also belongs to the individual perspective, that they will identify the core value of the rule of law in protecting of individual liberty. And for the asymmetry argument of the rule of law, my claim is actually very modest. I want to say that rule of law makes a claim. It requires it requires government officials, it requires ordinary citizens to apply the law, and it has normative justifications for this. And that's enough. And it's a very minimal level. And if you go to higher to compare this normative force between the individuals and the government, yeah, I think this is an interesting point, and I can develop this further. But so far, my claim is that at very minimal level, that the rule of law claims that all members within this community apply the law. So if I have time, I will explain why I disagree with Postimar's claim that holding each other accountable under the law is not suitable as equal status of what individuals do. My claim here is that Postimar's goal of making each other accountable under law is to solve the problem that the political power will not be effectively limited by the law. So Postimar's goal of asking ordinary citizens to take government accountable under the law is that he thinks that government needs supervision, or else it will be arbitrary ultimately. But what I want to say is that this may be true, this may not be true, but we still have a very minimal understanding. Let's come back to the very first starting point, is that the rule of law not only claims to limit arbitrary power, it also claims everyone within this community interact with each other according to the law. And it's a very minimum claim of applying the law. So if we use holding each other accountable under the law, we will inevitably suffer from the legislative problem, and we will inevitably be involved into the problem of separation of powers, supervision from civil societies. And all these are very rich ideas, and they may be involved in the rule of law, but my interest is not here. And that's why I use my title is The Conception of the Rule of Law, and I emphasize the perspectives. What I want to do is that I want to make this whole rule of law theory more complete. And sometimes I'm not disagree with your arguments. I just want to seek more of the rule of law and this more common understanding of the rule of law. Because of my general purpose of this project, is it normative? Is it just as I mentioned, that I think Postima provides two very important clues for us to understanding the normative force of the rule of law, and I try to develop it, and I try to develop a theory of the normative force of the rule of law. And you can see from my presentation, this largely depends on how we understand in virtue of what do members enjoy equal status. And I think Postima does not mention these points, and I think this is something we need to do in order to explain the normative force of the rule of law. It's universal. It is strong enough that it cannot be sacrificed in any situation. And it will connect to my argument of AI. And I hope if I have opportunity after I develop my AI arguments, I will connect these. The last one very important thing is that about the specific characteristics of the rule of law, specific characteristic and universal characteristics. My basic idea is that I follow Kant's argument that if this normative force is derived from the universal characteristics that is shared by human beings, Kant derives the theory of justice from these characteristics. So he claims justice enjoys prior status. So what I think is that if the normative force of the rule of law derives from these universal characteristics shared by all human beings. Learn in this situation the normative force of the rule of law. It will grant the rule of law a superior status. It cannot be sacrificed. And if the rule of law derives its force from the specific characteristics of individuals that is determined by each community, like we can see different some specific characteristics, and they are all arbitrarily. They are determined by history, by many so other things. I can give you an example that is on the immigration law, like how can we determine whether we should naturalize you or not? And this is all arbitrarily determined by the members within this community. And if the rule of law derives its force from these specific characteristics, it does not enjoy unbeatable moral force anymore. And in reality, that rule of law, the normative of rule of law includes both moral force. Okay, that's my response.
Thank you, Wang. Do not worry, that was excellent. Don't worry, this is good. We're all regardless of where we are in our careers, we're always in a process of learning. And there will always be questions that we can't necessarily answer immediately. And that's normal, and that's to be expected. But I hope the comments have been useful to you, and your project is going to make a very valuable contribution to the broader literature on the rule of law, which no doubt we need, certainly in this country at the moment. My thanks again to Dr. Lakin, Dr. Fusco, and Jeongwon for their comments and contributions, and indeed to everyone who's attended the session. Just to conclude, the Global South Network warmly welcomes PhD students from any discipline and any part of their world to share their projects and receive interdisciplinary feedback. Anyone interested can contact Dr. Jeongwon Ryu, who's the founder and convener of the Global South Network, at the email address, which will be soon provided in the chat. There we are, lovely. leicgsn@gmail.com. And indeed, if anyone here knows of any PhD students who may want the opportunity, please do share the details of the network and that email address. Okay, next week, let's meet our next guest speaker, Ianu Kolowole, who's a PhD candidate from the Open University Law School. She will be presenting her PhD project entitled Maritime Pushbacks and Human Rights Obligations, Reassessing EU Accountability for Transit Migrant Detention in Libya. That will take place on the 13th of August 2025 from 3 to 4 p.m. UK time. Thank you very much, everyone, again. Take care, look after yourselves, and I wish you all a wonderful day. Bye-bye.
Thank you, Tom.
Thanks. Bye.
Thank you.